Ever had a client ghost you after you deliver everything on time? You send the invoice, followed up with reminders, and still no response? Nothing. Silence. Now you are stuck. You did the work. You kept your end of the bargain, but they didn't. So, what do? You sue. And in today's video, I will walk you step by step through the legal process of suing a client who refuses to pay you for your services in the United States. Whether you are a freelancer, consultant, contractor, or small business owner, this legal guide is for you. Because here is the truth, most people will not tell you. You do not need to be a lawyer to win a legal case like this. You just need to understand your rights and know how to use the system. I'm going to break it down in plain English. No legal jargon, no corporate BS, just real, powerful knowledge so you can take back control. Let's get started. Moving forward with legal foundations. Why do clients refuse to pay? Well, it happens more than you think. And it's not always because they are evil. Sometimes it's miscommunication. Sometimes they are in financial trouble. And yes, sometimes they are just flat out trying to take advantage of you. But here's what matters. If you did the work and they didn't pay, you may have a legal case under US contract law. Now, even if there was no signed contract, listen closely. You might still have legal protection under what's called an implied contract or quantum merit, which literally means you deserve to get paid for the value you provided. In short, if you can prove you delivered the service and they accepted it, that's often enough to bring a case forward. And yes, that applies whether you are working with startups, influencers, local businesses, or corporate clients. So, what's your first move? We start with building your case. Let's move forward with document everything. If you want to win in court or even just pressure the client to pay you, you need evidence because in legal disputes, it's not about who is right, it's about who has the receipts. So, here's your legal evidence checklist: the original agreement or contract, emails or text messages confirming the scope of work, the actual work delivered, like of screenshots, files, designs, drafts, invoice copies, like of dated and numbered, follow-up messages, when, what, and how often. Save everything, even if it's minor. You never know which piece of evidence will tip the case in your favor. Still not a deal breaker? Many small claims court accept patterns of miscommunication as enough to establish a working relationship. So keep those events, keep those TMs. Your inbox might just be your strongest defense. Moving forward, final demand letter. Before you jump into court, it's smart to send a final demand letter. Why? Because courts love it when you have made an effort to settle things professionally. Plus, sometimes just the formality of a legal looking letter is enough to make a stubborn client pay up. Here's what goes in it: your full name or business name, their full name or business entity, the date the services were completed, the amount owed, a clear deadline, like of usually 7 to 14 days, your statement of legal intent. If this matter is not resolved by date, I reserve the right to take legal action in small claims court. Keep it polite but firm. You are not begging, you are notifying. And if you want to really tighten the screws, Send it via certified mail with return receipt. Moving forward with small claims court. If the client still doesn't pay, it's time to go legal. Welcome to Small Claims Court, the most accessible courtroom for solo business owners, freelancers, and independent contractors. Here is how it works. Step 1. Check your state's small claims limit. Step 2. Identify the correct code. Step 3. Fill out your claim. Step 4. Serve the defendant. Cost breakdown would be like of filing fee $50 to $200. Process service $30 to $80. Recovery up to $10,000 plus time to trial 30 to 90 days. Use legal billing platforms or collection assistants to track expenses. Many tools are advertiser friendly in this category. Moving forward with what to bring to court. This is it. The courtroom showdown. Don't panic. Small claims court is designed for regular people like you. You don't need a lawyer. Here's what to bring. 2 copies of your contract or agreement. A full printout of emails, texts, and call logs. Proof of service or delivery timestamps, screenshots. Invoices with due dates. Proof of your attempts to collect, like that demand letter. Also practice your pitch. You will have 5 to 10 minutes to explain your case. Be clear, calm, and professional. Don't ramble. Don't insult the client. Stick to the facts. Think of this like a business meeting with the judge. Moving forward with next one. If you win, how to collect. If the judge rules in your favor, congrats. You now have a legal judgment in your name. But here's the catch. Winning the judgment doesn't mean the money lands in your bank account right away. You may need to enforce it. Here's how. Wage garnishment, bank levy, property lines. If they still ignore the ruling, you can escalate to collections or even sell the debt to a debt law buyer. Court judgments are valid for years and can grow with interest. Don't walk away empty-handed. Use the power of judgment. Going forward with the next one, avoiding future non-payment. Now that you have seen the battlefield, let's talk defense. Because prevention is 10x easier than lawsuits. Contract best practices like of always get a signed agreement. Include late fee clauses. Use payment milestones. Add an arbitration clause. Tool recommendations like of use escrow-based platforms. Sign contracts digitally. Use Stripe, QuickBooks, or FreshBooks. Set boundaries in your contract. Not after things go wrong. Moving forward with next one. Post-court strategies. So, you have gone through court and maybe you have won or maybe you didn't. Either way, what happens next is critical. If you won and collected your payment, great. But now it's time to upgrade your systems to make sure you never waste energy chasing down payments again. Create a red flag client checklist like of vague about payment terms, slow to respond during onboarding, trying to negotiate your value down early. These are signs they must cost later. Also, review your service agreements. Add clauses that allow partial payments up front and auto bill on milestones. Consider using contacts that reference jurisdiction so you always control where a lawsuit would be filed. If you lost in court, don't give up. You can often appeal or you can still report to the client, to professional boards, leave public reviews, or use collections. But here is the mindset shift. A lawsuit isn't just about the money, it's about protecting your brand reputation and sending a message to other potential clients. You are not just a freelancer, you are a business. And businesses enforce their value. Never be afraid to stand up for yours. Here's the truth. You have the power to protect your work, and you don't need to accept unpaid invoices as just part of the business. Now you know how to demand payment, how to document your case, how to use the law to enforce your rights. This video wasn't just a guide, it's your legal shield. So here's what you do next. Like this video if it helped you. Subscribe if you want more freelance legal strategies. Because it's not just about getting paid, it's about standing up for your value. You earned it.